Fair housing law is about having an equal chance to have a place to live. It's your legal right to stop housing discrimination, from where you can live and how much you have to pay, to how you're treated and the rules you have to follow when living there. This means that people can't be treated unfairly because of their race, or being from a certain country, or having a child, or having a disability. Sometimes housing discrimination is obvious, but other times it is hidden. Like a landlord falsely telling an immigrant that there are no apartments available so that they can rent to a white family instead. Or a manager refusing to change a no pets policy so someone who is blind can have a service animal. The Fair Housing Act was passed in 1968 to try to end housing discrimination and segregation. Both were widespread in many cities and towns across the country. For example, sometimes deeds said only whites could live in a property. In many cities, lines were drawn on maps around minority communities, a practice known as redlining, to show which areas would not be given loans and other investments. Although these practices are now illegal, housing discrimination is still a problem. Today, communities and lawyers still use the FHA to fight discrimination and to help build integrated neighborhoods. Federal and North Carolina fair housing law prohibit housing discrimination because of race, color, religion, national origin, sex, familial status, and disability. The law protects all races, religions, immigrants, and their families, people of all genders, families with children, and people with physical and mental disabilities. You cannot be denied housing, charged higher rent, or treated differently because you are in one of these groups. Landlords, property managers, real estate agents, lenders, and others all have to follow fair housing laws. They are also prohibited from saying discriminatory things or posting discriminatory ads. The law also says they can't make false statements about availability. Fair housing laws apply to all kinds of housing: public, private, subsidized, even mobile homes. Here are some common examples of violations of fair housing laws. Race. An African American family tries to rent an apartment and is told that there are no units available. They suspect discrimination, so they ask a white couple to try to rent the same apartment, and they are offered it right away. Or a property manager waives rental application fees for a white family, but not for people of other races. Disability. People with disabilities can ask for reasonable changes to housing rules, sometimes called reasonable accommodations. They can also ask for physical modifications to the property, sometimes called reasonable modifications. Imagine an apartment building that refuses to reserve a parking space for a person who has difficulty walking. Or a landlord that refuses to allow a tenant to install grab bars in the bathroom. Sexual harassment. Sexual harassment by a landlord also violates fair housing laws. For example, a landlord, or their employee, that demands sex when a tenant can't pay rent or makes a lot of sexual comments to a tenant is violating the fair housing laws. How can fair housing laws protect you? You can file a housing discrimination complaint with the U.S. Department of Housing and Urban Development. You can do this online, by phone, or by mail. You don't need a lawyer, but you must file your complaint within 1 year after the discrimination occurred. You can sue in court. You must file your lawsuit within 2 years after the discrimination occurred. After that time period ends, you can no longer file a claim under the Fair Housing Act. You can even use these laws to defend against an unfair eviction. For example, if a landlord tries to evict a tenant with a service dog for violating a no pets policy. Do you need help? In North Carolina, contact Legal Aid's Fair Housing Project. We can give you information about your fair housing rights. You can reach us by email or by phone at this number.